Well, now, ladies and gentlemen, we move forward with our last panel for the day. And this panel discussion will revolve around the topic and era of smart pills in pace with the tech track. I would like to invite my moderator for this panel, Mr. Dhir Dhir, Head Legal and Company Secretary, Siemens Healthineers. May I please have Sir on the stage? Welcome, sir. He's the head of the Legal Company Secretary at Siemens Healthineers, a med tech company of Siemens Group. In this role, he is responsible for legal affairs, corporate governance, and compliance. Prior to Siemens Healthineers, he was responsible for energy business for Siemens in South Asia. He has over 18 years of experience in legal counseling, litigation, regulatory, corporate governance, taxation matters in India, as well as multinational companies from the West and the East. Mr. Dhir is a committed business enabler, creative problem solver, and a legal strategist. Let's have a huge round of applause as we welcome Sir on the stage. Welcome, Sir. Starting with our panelist, I may like to invite Mr. Abhishek Malhotra, Managing Partner, TMT Law Practice. He's the founding partner of TMT Law Practice, nearly having 2 decades of experience in the legal realm and is a member of both the state bars of California, USA, and Delhi. His primary areas of expertise are intellectual property, dispute resolution, and the technology, media, and telecommunications industries. He has advised clients in minimizing legal risk and devising strategies for safeguarding against criminal and civil liability. Let's have a huge round of applause as we welcome Sir on the stage. Welcome on board, Sir. Our next panel, may I invite on stage Mr. Ashish Prasad, Partner Economics Law Practice, who is in the litigation and dispute resolution practice of ELP and is based in Delhi. Mr. Ashish has a vast experience in handling commercial litigation and IP issues. And let's have a huge round of applause for Sir here. We'd like to invite Ms. Deepa Bhandare, Compliance Officer, Healthcare Business, India and Emerging Frontier Markets, Merck, India. Total work experience of about 25 years, including working for brands like JCPenney, Woolworth, Germany, Walt Disney, and many more. Ladies and gentlemen, let's put a huge round of applause as we welcome Ms. Deepa here, who possesses around 8.5 work experience in supply chain management and healthcare compliance in companies like Abbott, Johnson & Johnson, and currently Merck from January this year. Let's have a huge round of applause for ma'am here. Welcome, ma'am. And joining them on this panel, may I please invite Mr. KPS Kohli, Partner Dhir and Dhir Associates. Mr. Kohli joined the legal profession in 2007 and has rich experience in domestic and international dispute resolution. He has represented various ministries, PSUs, corporate houses, and Fortune 500 companies in industries such as telecommunications, oil and natural gas, aviation, and banking. Let's have a huge round of applause for Sir here. I request you to take it forward.
Yeah. Good evening. I think we have a good crowd so far. I think till the end of the session. I think let's start. I think it is very clear with respect to the why we need data privacy, the legal requirement and the safety and security reasons. But I think to start with what exactly how the data is really changing. Not only the economy, but also what is happening throughout the country. So to start with, I think what we have planned for this session, let's make it interactive. So we'll start about the small introduction about the e-pharmacy and e-prescriptions, and then we'll move to the digital health blueprint that is currently in the sphere and needs comment and for implementation, and then we'll talk about the data privacy, the personal data protection law versus the GDPR, and then we end the session with talking about the artificial intelligence and the patenting capabilities, whether it can be really patented or not. Now, if I see the look back, and all of us know that if you see the last 10 years, we'll find that most of the innovations that is happening is through data. Now, whether you see the hardware remains same. So if I talk about my industry, medical device industry, the hardware remains same. What is changing is the software. And similarly, the biggest innovators or the companies who are growing very fast, they are all driven by data. So data is critical, and all these startups which are coming, most of them are coming out using the data, and data is something which is going to be the enabler going forward for all this industry. So having said that, so the way the data is gathered, collected, and stored, and used and retrieved, we have several challenges that we find, in our day-to-day practice. So coming to particularly the theme, the way we are looking at the e-pharmacy. E-pharmacy is currently going to be, in another kind of e-commerce where they can really make the medicines available throughout the country. And in India, the way we are so big in terms of how can the medicine be accessible and reachable to even rural people, I think we feel that e-pharmacy can make that happen. So let's start because we have been seeing that there are a lot of growth potential for e-pharmacy, but apart from the growth, we also see that they face a lot of challenges from regulatory perspective. So to understand that, what exactly the challenges that we are seeing in the e-pharmacy sphere, maybe I would like to start the discussion with about the challenges that we normally face, and also we have a couple of judgments where they have already stated in the Madras High Court, and also we have a judgment from Delhi where a lot of negative vibe is there with as far as e-pharmacy is concerned. So therefore, I would like Deepa, maybe you can just start giving a brief about the challenges so far for the e-pharmacy sector in India.
Yeah, thank you. E-pharmacy basically has been talked about since 2015, and FICCI was given the, from the government or the Ministry of Health, they asked FICCI to draft certain guidelines, and there was a subcommittee formed, and there were like draft rules which have come out now on August 28th, which talk about the various, the guidelines as to how it needs to be followed in terms of, because currently there are no specific guidelines for e-pharmacies and e-prescription as to how it's actually understood by the industry. So if you look at e-pharmacies, we specifically talk about, the challenges which we first see are data privacy, data protection, also in terms of patient confidentiality. So how do you ensure that the information about personal information about patients is taken care of, whether they are registered. So currently, the way it's looked at as by the industry is whether you are, if you have a license or a registration, an offline pharmacy can be actually also doing business online. So, which is the inventory-based model, whereas marketplace would be something like an Amazon or a Flipkart, which is which connects the ultimate offline pharmacy or the chemist store to the end customer, that's the patient. So the challenges which we look at is because there are no, firm guidelines or a process which needs to be followed. Data privacy protection, these are basically the challenges. Even children can actually, so even minors can order online stuff. So even the, self-medication could be one of the cases which would be also the kind of challenge that you could see online, because everything is at a click of a button, and the most, the basic, I think the burning challenge would be even your narcotics. So currently the narcotics and the psychotropic drugs, which are under the Schedule X drugs, they also, are banned for online pharmacies to be sold, but just in case that could be a possibility if the companies like NetMeds or PharmEasy, they have said that they do not sell them online, but there could be a possibility, and even the legality in terms of whether those e-pharmacies are actually, registered and are legal.
Yeah.
That also becomes a big
so I think the challenge. So I think actually, under drugs and cosmetic law, we know that for selling, storing, and distributing any kind of drugs, they need a license. Now it is not very clear in the drugs cosmetic whether that particular sale also includes online sale. Now when it comes to online sale, there are, as Deepa has pointed out, there are kind of inherited challenges that we all face in online kind of transactions. So therefore, I think whether there is in fact there is a need, and also there are two judgments which I would like to Ashish to point out what exactly this two judgment, what is the reason behind this new draft law which has come into play now, which is still not a law. I think we see that it is going to happen in any time sooner. Ashish.
So the fear is quite large that a lot can happen if we let drugs be issued to people who don't know, or by people who don't know how to handle the drugs. And that's possibly why there's a need for a regulation, because the marketplace has really expanded and access is available to certain types of customers who may not be the right intended market. Led to a lot of uproar, litigations, of course, tried to stop the entire operation of selling drugs online. But what does it really mean? There are two ways of selling any product today, actually, and especially after the IT Act came into being, or the invention of the WWW, World Wide Web itself is like a marketplace has now changed from a brick and mortar to an access on a website, actually. So clearly, there is a debate that how do we regulate, and do we regulate at all or not? Is there a need itself or not to regulate people to sell their drugs or make available the product online? So long there is nothing. I mean, there's been three litigation, and I think most of us are aware of that. The Madras, the Delhi, and the Calcutta one, which are more or less harping the same issue, saying that look, stop them all from selling drugs online or for making available drugs online. Okay, next debate, because we need regulation, because the fear is too much that they possibly are selling without licenses. The question is like, do you need any license to sell drugs online or not? Oh, sorry, we don't have that framework yet. Okay, so we are making a framework now. So let's make a framework. So we are making a framework, so till that time should I stop them? Oh, we can't stop them because others are allowed to sell their services and provide whatever they can provide on a platform which makes it look like a marketplace. Marketplace is somebody who's doing legitimate business is being connected with a consumer who would otherwise have to travel and get that stuff out. But would he follow the right procedure for dispensation and and would the shop give the drugs, seeing prescription depending on whether it's a Schedule X narcotic or any of the Schedule H drugs, for example, under the DNC Act? If those rules are being followed, we can't stop them. We will just need to incorporate those rules and the standards in the shape of a regulation so that there can be a tighter scrutiny before this thing takes off, or before we allow or we regulate it. We need regulation because it's a question of drugs, so we should regulate it, or we should do it very soon. After the first litigation, no, we should do it very soon. Within a month it should come out. That month has gone long back. That month, and the question keeps coming back one after another. 3 attempts have gone. Zahir Khan, Tamil Nadu, in Chennai, and then after that Delhi High Court. They're only getting dates. The government has come back very clearly and said, oh, we need more time. Why? Because a lot of inputs have come. And rightly so, because the issues is not only limited to access and dispensation of drugs, it leads to data, which is a much bigger devil actually out here in disguise. So that's where we are today. We don't have a regulation. Till that regulation comes into play, somebody could have said when we were just reading outside, what kind of a news can that be, that there is a ban on online sale of drugs, which according to me is not true. So the limited injunction given by the Delhi High Court in Zahir Khan's case was very simple, that look, if you're not authorized to sell, don't sell. If you're not authorized to do business, don't do it. But it did not mean that anybody can't sell or make for available drugs in a market space if you're otherwise complying with other regulations, which is having a pharmacy, having licensed practitioners to dispense such drugs, and it is made on a prescription, and you're following the process completely. So
Yeah.
that's where we are today,
Yeah.
and we are
So-
waiting for the right regulation
Correct.
to come into play.
So I think
There's
the
one aspect that I wanted to bring in, what we were also discussing outside, in addition to the aspect of whether or not there is a licensing or a registration that you have with regard to either the pharmacist or the physical location itself. The challenge that I think would need to be addressed as we go by, once it becomes a legit, regulated, properly effectuated business, is the aspect of how do you authenticate the prescriptions. So when, of course, one of the aspects that you have is someone wishes to buy the medicines, and they upload the physical prescription that they've got from a doctor, which will of course be just a scan image uploaded on the portal, and that then you're dispensed with exactly the same kind of drugs. But what if we move more in the domain of an e-prescription? Currently we don't have a definition of that, but I would think that perhaps it will necessitate a digital signature and those aspects being followed. It will, or alternatively, if you're looking at the possibility of a questionnaire being set out on the portal, which you are populating with your ailments or whatever issues that you're having. Then at the back end, if you have that registered pharmacist, perhaps you have a prescription that's generated, and then drugs are dispensed. But as I said, as this entire business evolves, we will see whether there are any pitfalls, and if so, what they are, and how to address those. One big one perhaps could be the aspect of counterfeit medicines. When you're going and buying it at the physical location, perhaps there is a way of figuring out what is counterfeit and what is not. When you're in the internet domain, that difficulty increases manifold.
Yeah.
So, I mean, just issues for consideration,
Correct.
food for thought.
I think also to add, I think the Delhi High Court, because Zahir Khan is a familiar name, it is Dr. Zahir Ahmed's case. So now also coming to another aspect of the way the business models that are operated, there could be two kinds of business model that currently the e-pharmacies are doing business in. One is the platform, just like we have seller and then buyers, like patients who buy medicine, and there is a seller. And the company, the pharma, the e-pharmacy company is only providing a platform where they enable the meeting of the suppliers and then the patients. So this is one kind of business model. The other business model where the e-pharmacy is only selling. So it is providing the platform as well as doing the selling. So as far as the law is concerned, it is very clear, the draft law, that the e-pharmacy who is selling the drugs needs to have a license. Yeah. Now in the previous model, so the legal or regulatory question is, because he is providing only a platform, he is not really selling the drugs. So therefore, the Drugs and Cosmetic Act is not applicable. Maybe it is the IT Act is applicable. So the seller has already a license, because so he makes sure that all the sellers who comes to their platform or register in that platform, they have a license. So under the Drugs Act, they can sell. Patient, definitely they can buy from there. So now the question is what about those e-pharmacies where they are only providing the platform, not having kind of really selling those drugs? I think the law is still not addressing this. I think because the law is saying even the current law, the draft law, which is still in the draft stage, is only talking about selling of drugs through online. So they are required, but whether the platform needs to follow certain guidelines, whether they need to have a registration with drug licensor, it is not very clear.
I think how I see it playing out is, I mean, I am comparing this to a regular e-commerce platform. So the default position is that such platforms will seek to get the intermediary exemption under 72. Yeah. And then, as we are seeing in other cases of IP infringement, increasingly the courts are saying, look, you can't go scot-free. You must have little bit of a due diligence exercise to at least ensure that the basic levels are being met. So in our case, let's assume that the person who's actually selling on on the marketplace needs to have the relevant licenses, at least do the due diligence to find out whether those sellers have those licenses in place or not. So we will see, as I said, evolving space, we will see how this is, plays out.
Just to add, maybe the Information Technology Act 2000 is going to be applicable, and maybe even they're talking about in the new draft guidelines, they're talking about the internet intermediary liabilities as well as cyber law due diligence.
Right. Yeah.
So maybe that due diligence, if those draft guidelines, those haven't been really drafted yet, but I think that would be the next way forward.
So I was just saying that all this is new, so probably it will evolve in time. Like a separate market, like for food aggregators, they have also received notices where they have said that you take a FSSAI registration, although they are just an aggregator. So probably that's where we'll see how it will evolve and take it
So the question remains of accountability actually. So if you are one of the chain which helps in delivering and you are a part of the whole process, it's easy for you to state that, look, I don't want to have any accountability, because all I'm doing is actually like a broker, I am just connecting you, and I don't take any responsibility whether the house that you'll walk into would be livable or not. But it's much more than that, of course, here. The accountability part is what intermediary liability we're talking about, and I'm quite sure and very positive that government out here is not going to let anybody go who's going to be a party in the process.
So on the e-pharmacy, I think the challenges that are really, just to clearly share with you, that the challenges what is going to have is with respect to the business models. Then we have the challenges of data localization. I think the draft law clearly talks about the patient data that is gathered or that comes to the e-pharmacy needs to be local, needs to be stored in India.
67K.
Yeah. So I think, and also there is another requirement with respect to, to maintain confidentiality and all the provision of the IT Act, because one is compliance. The e-pharmacy has to comply with the IT Act. Then, all the regulation with respect to maintaining confidentiality and privacy and the criminal liability in relation to that will apply. Second is about the data localizations. I think these two things, and then then complying with the e-prescriptions requirement, the electronic or digital e-pharmacy. I think the two, to complete this discussion with respect to e-pharmacy, I think it needs time to think about the challenges, how this can be dealt with in times to come. So we now move to the digital the healthcare blueprint. I think if you see the national health policy, it talks about the universal health, and if we want to make healthcare accessible to everyone, I think health for all, it is important that how can we take help of the technology, and how can we really implement or gather this kind of to have their framework where I think all the data about the patients and the service providers and cleaning can be easily available. So it talks about the different frameworks, including the electronic health record standards, how that can be really built, because currently I think it is very difficult that to find out what has happened 10 years back. What kind of medicine did I take 10 years back? It is not known to me. Even you find a lot of challenges. So how can we make this really, make this happen, that you just go to a doctor and share your mobile number, and then the doctor can able to see, from the date of birth till now, how you are really, how's your healthcare so far been.
History looks like actually.
History. So maybe really it is a good thing, but it also comes with a lot of legal, regulatory and ethical challenge. Maybe KP, you can share your thoughts on this, that the challenge, because it is still a framework, it is not a law. I think we have had a draft law also, DISA, I think Digital Informational Security in Healthcare Act, which is still not become a law. So if KP, you can just share your thoughts that what kind of challenges. Yes, it is good to have this kind of electronic digital healthcare in the country, and it has definitely a lot of positives, but what exactly the challenges from legal and security perspective?
I think since DISHA and PDP, Personal Data Protection Bill, both are somehow joined, although both are came together, one came in March, one came in July, but both are still in the draft stage. We don't know what the final outcome would be. But I think it's a good move forward. Of course, once you have everything digitized, so it's easier. You don't have to keep physical copies. Your entire medical record would be online. But of course, there are various challenges which are under the Act. One, of course, is consent. And under Disha, initially it has to be an informed consent. There has to be a specific consent for taking the data of the person. Second is the security of that data. I mean, I think that's what is more important is how the data is preserved. What are the liabilities of the fiduciaries who are actually preserving that data? So that's a bigger challenge, because whosoever will preserve it, there are so many aspects to it then again. One is that who to share it with. Second is that how it is preserved, who has the access. Third is updation. So the liability is also that when it is to be updated. So that's again a bigger challenge. So that will be probably the challenge whosoever will come in and look at it. So these are the three basic challenges that anyone will face.
And also, Ashish, if you can just talk about, because see, maybe I am currently in city of Mumbai, then my data is available. So how it is possible, how it is anticipated, in fact focused in this particular policy, how the transfers of data, how they can make this data, health data transferable from one hospital or one clinic to another. So whether there will be a cloud which will make it enable, or what kind of, because this is a pure science.
No, I think, and KP also said it right, those challenges will remain. The idea that we are looking at is how controlled transfer can we do. So there is accountability that the data is not breached and it's not fallen into hands where there you start getting home loan calls actually, or start getting calls from diagnostic insurance calls, or diagnostic people. There can be many guys out there actually who might be looking for and buying for. I mean, this is not new debate today that data is the new bomb that we are looking at actually, which is the next power. Anybody with data has power today to analyze them. It's another thing that a lot of data can be actually junked into hard drives which nobody can look at, but somebody starts looking at that data is very relevant. What the challenge that we are facing, and what KP also rightly said, we are looking at controllable dissemination of data and transfer of data. Now, obviously, data localization is one part. We are living in the era our premiers being Modi and Trump, and saying that, look, mine is mine, I will not give anything to you, you will not give anything to me. And then we are looking at a sector which will grow, and innovation will happen only based on prior data and history. I mean, for me, if I go to a doctor as a consumer, the guy wants to know where you were born, how you were raised. Did it happen to you earlier? Did it happen to anybody in your family or not? That is what is happening there. There is an exchange of data. But that data is relevant data for the purpose of examining and coming to a conclusion actually. That data, because you trust, so it brings us to a question of the challenges in the e-pharmacy space or in the Disha space, and then we are looking at harmonizing all these laws together. Again, data. We trust the provider, we trust the service provider, and we are able to give that data. If that trust is maintained and that trust is respected, then we are not looking at a breach. And if there's a breach that happens, obviously that needs to be controlled.
I think just coming in here, I think the focus of the digital blueprint, health blueprint, is essentially to get all the stakeholders on the one single platform, so that there is a possibility to have an effective interchange and exchange of information. So, and the blueprint very clearly sets out this mandate that with regard to the aspects of privacy and data protection, we are not giving any sort of solution, because that's the overarching legislation that is going to take care of it. So whatever we say today may become irrelevant once the act comes into force. I think I'm just stepping back in time, in history. The reason why I think this is also the need for this has come about is not only the aspect of the development of technology, But in the, let's say 50, 60, 70, 80 years ago, when a person was typically born in a particular place, they would spend their entire life in that particular place. There would be a family doctor that one would go to, and the reason for that was that that person would know your history, medical history, perhaps your family's medical history, and then be able to use that as an effective tool in clinical diagnosis. Today, when there is so much of movement, not only within the same border of the same country, but also geographically across the different parts of the world, this is only an effective tool to be able to have two different hospitals or service providers be able to interact and say that, look, the reason why perhaps this person is having this particular ailment is based 15 years ago in some other ailment that they've had, and this is just a repercussion of that. So if in my childhood I had an issue with regard to my rheumatism issue, and that is just acting up 15, 20 years down the line, there is at least something for that doctor to go back to and say, look, this could be one of the areas that one could look at. So I think the entire purpose of the blueprint is to create this interchange, if I can call it loosely that, for lack of a better word, when we're transferring money from one bank to the other, the digits that are getting transferred, no physical money gets transferred. So you have this effective interchange where people are able to exchange information and correlate and act with each other. But for that to happen, it's a gargantuan task, because you have to get all the players in the ecosystem on board for it to work effectively. Your hospitals, your clinics, your insurers, your doctors, your patients, everyone. And that's a massive task. So I'm hoping that it will happen. And of course, the overarching concern that all of us clearly have of privacy, to my mind, that's more addressed by the PD people.
Just to add that part, you see, none of this progress can take place actually with, I'm saying subject to just exception, which are actually saying that, see, you can't stop innovation, because that is what will lead to better practices.
Yes.
And, development in R&D, it will be based on data. Today we are looking at data protection on many for us right now. We are looking at biosimilars. When you look at innovators, we are looking at extending the data protection actually so long. Why? Data is power out there actually. And one data, in fact, to that extent, I go back in fact to my IP days and say very clearly, look boss, you were given certain kind of monopoly. Why? So that you could invent. You could invent why? Again, so that people can benefit after your invention has lived its life for your benefit. So you cannot have all these restrictions in play and restrict the growth of innovation. So I guess, like for example, there are many new diseases which we are faced with today actually, which didn't exist earlier. We don't have a solution out here. Now for that, you need to send your data to, so let's say, very specialized hospital in DC, and then you are faced with the challenge that I can't send the data out. You have a genome structure out here. If you send it out, it will be breach of data, privacy laws and data laws of the country. But I'm sure we will find a way in which all this will be made to work together and still not breach certain.
So now, one part is about, this is really, there are a lot of benefits we can foresee. Now coming to the disadvantage side also, so what it can lead to. So, when we see that this is a framework and also the law is not there, but in all these cases that we have been discussing, I think two sections, I think if I draw your attention to, that the section 43A and again then 72A, I think these are two sections which clearly inapplicable all these cases. Because these, so one is the breach of privacy, there are liabilities, and also if somebody gets into your computer system and accesses and get this data, they are liable. So whether do you see a need for additional provisions on these laws, whether it is the DISA law or e-pharmacy law, whether do we need additional provisions under this law as far as offences are concerned, whether these offences anyway is going to be addressed by the IT law. So any thoughts, any of you?
I think, I think the entire purpose of the IT laws, the Information Technology Act, was to bring to the digital domain what is already there in the physical domain. So a lot of that has been interpolated, and of course certain aspects that are only specifically doable in the digital domain, for example, the hacking, etc., and the other criminal liability that accrues from that is specific to that. Now, when we are talking about delivery of, either through the e-pharmacy model, or we're looking at issues on data privacy, or we're looking at any other breaches that are coming about, each of the specific laws will provide for the consequences of those breaches. The only enabler that the IT Act is providing is that if you are to do that sort of act or omission in the physical space, that particular act addresses it. I am only transposing that liability to the digital domain as well. So, to my mind, the relevant law which applies to the particular industry or Drugs and Cosmetics Act or any other law as that, PDP as the case may be, those will address the bulk of the liability. It's only the transposition to the digital domain which will be enabled by the IT Act. So, I don't think that IT Act needs to be further strengthened with additional provisions to enhance the consequences of such liability. Those, to my mind, already exist.
Yeah, I think we need more enforcement of that rather than
Undoubtedly.
But which is the same question we face every time.
But I think once the overarching data protection bill, law comes in, that will prevail over everything else. Because data protection bill proposes certain penalties and fines and also imprisonment if there is a breach. So I think once that comes in, that will act as an umbrella for all other subsequent laws in terms of dealing with data under various facets of a human life. One could be e-commerce, one could be pharmacy, one could be purely for doctors, one could be food. So all that would be defined principally under the Data Protection Act once it eventually comes in. So it's actually an ecosystem for the digital world, which will regulate your digital life, so to speak, which is, I think, more important now than the physical one.
True.
So I think everything would be governed by that, and every sector specific it would be. Probably, let's say for Disha, barring a doctor, barring a hospital or a nursing home for breach of data. So there are so many, in every, there'll always be a data principal, then there'll be somebody who's actually collecting that data, there's somebody who's storing that data, and there'll be multiple people who are using that data. So for each sector, although data protection bill provides for a framework as to for each organization who's dealing with data of somebody, how that organization would maintain, preserve, update, and what security it should entail so that the data is not breached or I would say is not hacked. So that is already there, and thereafter each sector specific provisions would be there, that for a hospital how much liability or penalty, what is their responsibility while using that data, or somebody who's storing somebody's medical records, which under the data protection bill is a very critical sensitive personal data, and that data you can't take out at all outside of India. So those are the things. Data protection bill probably will be the umbrella legislation, and then rest would be derived from sector specific, saying under this sector probably a hospital would have XYZ liabilities, but you will have the similar obligations under the though that hospital or that repository who will store medical history of somebody would have the same principles built into their system which the data protection bill envisages. That is privacy by design.
So I think as you have already started discussing, I think we should move to the data privacy and how the personal data protection bill vis-a-vis the GDPR. Now, as you know, after the Supreme Court judgment in this Sri Krishna committee thereafter, so the bill is already in force, but we see a lot of hue and cry about certain topics. I think if we like to, Abhishek, if you like to draw to us with respect to the GDPR, how that because it is already more than a year of implementation of GDPR, we see in European companies how critical it has become.
Correct.
And when we see, and the implementation is really a challenge, if you can say the experience being in a European company, I see that it is a everyday's work. I think the amount of cost and amount of time we normally give to a data privacy topics, because everywhere in healthcare companies, whether it is pharma or medical device, every day you encounter not only the employee data, but also the data of the customers and also the data of the patients. So therefore, this data privacy is very important topic, and the amount of penalty that has been contemplated under GDPR. So vis-a-vis, when I see that the new law, the draft bill, what are the 3-4 main challenges or differentiators that you see in this PDP law?
Sure. So I think, and I'll try and restrict myself to, because the topic is more in the pharmaceutical realm. So I will try and restrict myself to the differentiation as impacted to the healthcare industry. So the first thing, of course, is while there is a mandate for data localization, however, the liability or who decides where that data is actually stored, there is no provision for a data subject to actually demand for where that exactly that location of the data is stored. So that in fact becomes the biggest challenge, because from a data subject point of view, if I want to know where my information is stored, let's take a live example. I was talking to someone today and said that they were saying that look, there's a possibility that Columbia Asia is wrapping up its operations in India and moving out. Now, currently that data localization is not a mandatory requirement because the PDP is still in the bill stage. If the data is actually stored outside and there is no liability or no way that only the data controller will decide where it resides, and there is no liability or no requirement for them to relay that information to the data subject, the entire purpose of our digital blueprint goes for a 6, because then we do not know, the entire workability falls. So that's one of the aspects which is differentiated between GDPR and our bill. The other challenge is, okay, I'll actually address it in a different manner. I think one of the aspects of the criminal liability clearly is one differentiator, and that's something which has been a maximum hue and cry, that you possibly can't, under the garb of something where there could be mere negligence, there could be a lack of understanding, there could be various other contributors to why there is a breach of these regulations. You can't possibly impose criminal liability, it will result in another witch hunt. So that's one major concern which is sought to be addressed. The other thing, however, I am saying is that as and when the PDP bill does become an act, there are two, I think, positives that we can see. One is most of the businesses, as you rightly saying, a lot of time, effort and money is going in to just educate people within the company and to bring in compliances in place. So the most important, I think, positive is that we have had the implementation of GDPR reasonably proximate in time to the applicability of establishment of the law, the right of privacy, and an offshoot of that being the PDP bill, and which will hopefully result into an act very well. The second aspect, the positive, is that we don't need to be scared that it is going to be implemented on the day that it gets enacted or notified. There will be a period, possibly 18 months is what is being contemplated, during which even Indian businesses will have to undertake that compliance module, get familiar with it, undertake enough training sessions, so that when that 18-month period or whatever period comes to an end, the compliance then becomes effective. So to my mind, I think that ecosystem has been built in such a manner, and I'm hoping that some of the glaring red flags that have been raised during the consultation process will be addressed once the next version of the bill is tabled. But I think that it's a positive going forward.
I think just to add, because data localization, I think the challenge, it is really, maybe a requirement, but the government has also a point, because, how do they approach in case of data breach the fiduciary? Yeah. But at the same time, when you talk about a lot of Indian companies who's going multinational, also multinational company doing business in many countries. Now the challenge is every country comes with data localization. Then how many copies of the data needs to be stored in every 100 countries?
No, not only that, it's, what is the trickle down effect, and I think it was a report by a consulting company that in another 5 or 10 years, the biggest consumers of power, of electricity, will be data centers. So if you are going to have that sort of an impact, the other issue specifically with India, you cannot have a data center in a seismic zone. So therefore, effectively all of North India is out. You're only going to be limited in pockets of, let's say, Hyderabad or Bangalore or whatever, or Chennai. So if you're going to have only data centers around this, and then the data localization will mandate having such data centers here. Is there an alternative solution that could result in both an equitable and efficient utilization of resources, and at the same time achieving what you want to achieve, which is essentially to have data accessible at the time that you want it to have access. So I mean, I get your point.
Yeah.
Data centers is,
So
and
data
data
centers
localization is going to be a big issue.
Data centers are going to be new factories actually, or you can see,
Absolutely.
which would be polluting, of course. 24 hours you'll have to run them.
So another aspect about the function of the states, because I think maybe any of you can address this, because one of the significant aspect of this new law which says that government can use the executive by way of law. I think the argument is, if the law provides, it is not government, but if the law provides that your data can be used, they don't need any permission of, because it is the interest of
Security
the interest of
and
security and national security. So therefore, how do you see that really being a challenge?
See, my view has on this been very straightforward, that I think there is already a framework which provides for that government can access your data. So there is already a framework law which permits that government can always access your data. In fact, under the data protection proposed bill, there is an equal obligation on the government that when they say that how they treat your data. So I think that's a right step in that direction, because under the present IT Act rules, there is no obligation on the government as to how they protect your data. But under the Act, it identifies that it is for the companies and also for the government, that how they deal with your data. With respect to access to the data, now that's a very, it's probably a personal question to everyone, because since I am a lawyer and I'll be advising somebody, government can access my data equally. So it's a question which is more personal than legal. So I think they can still anytime can access my data under the present framework. If, of course, it has to be through a process of law. Now, under the data protection bill also provides for that process, and I think that's a better way, that we have a mechanism where everything is streamlined. And I mean, if I have nothing to hide, why would I fear if government is looking at some portions of my legal framework? In any case, is stored. It is already in public domain. Somebody is already storing it. So I don't see any reason.
Yeah. So I think. Maybe we can move to another interesting aspect before we conclude the session. Is how the artificial intelligence and machine learning. I will give a couple of examples, at least from my industry, medical device industry. So we sell medical devices, the big high technology machines like MRI and CT scan. Now, as I said, because these equipments now is exactly same. Maybe a little smaller, but it's exactly same. But what is the innovation that these companies are bringing is through softwares. So now the softwares, if you see, software is also moving to the next level of which we normally call machine learning, deep learning, and artificial intelligence. Now the question is, so what exactly, how this is used in our industries? To give an example, so what the software is currently doing, they are able to connect all the CT scans, say for example worldwide. So we have, say for example, cells, lot of CT scan. It is it is installed. It is used by the radiologist. When you able to connect these machines, and you provide them a software, and the software will allow you to assess what kind of image in a particular machine, and the radiologist will also able to see whether similar image has been there anywhere in the world. In the just click of a button, he will see if because the software is compares the images to give insight to the doctors or radiologists. So if a particular image shows then they can see the data or what kind of report was generated and what happened to that patient, and this insight what they get. It's really helpful to predict, predict the kind of disease, 3-4 years in advance, which normally very difficult to. And in medical science, if you predict it 3-4 years in advance, the chances of cure is very high. So that is the level of innovation that companies are doing so far, maybe the pharma companies. But the challenge in this kind of software is how to protect this, because the protection of this because these are the next level of software. It is not software because software is the base model which extract or decide data, but then the software again learns on its own. So therefore, if you can, the way the artificial intelligence and machine learning, the next step level is deep learning. So if you these three stages of a particular artificial intelligence, you see that we are at a very nascent stage of learning, which is a weak artificial intelligence. So then there is a concept of strong artificial intelligence. Then there are super intelligence, where they can really behave like a human, even more than they can do the complex work. Now the question is whether this artificial intelligence, which is the next level of software, can really be patented. Yeah, I think that is what we just want to also share with you, because it is still at a very stage that it has not been really explored in India. The current scenario, if you can share, because we also had discussion that whether this artificial intelligence, one is the first base level software which they can extract. I can give you another example from legal, how artificial intelligence can help read your contracts. We are working on various artificial intelligence which can read the tender document and summarize the tender document in a particular format and identify the legal risk in the tender. So for you have suppose 5-6 legal risks like limitation of liabilities, liquidated damages, penalties, and delivery period and all that. Then the artificial intelligence software, if you use, you can you can extract the data and give you in a given format. The next level is, this is called extraction. So the data is extracted by that software. But the next level is the machine will learn. If you give program into such a fashion, they will learn and summarize in a very exact way that you want to see it. So that is the next level. So because the first level is by human intervention, because the software guy has really developed that, but the next level there is no software, because his machine is learning and giving that output. So whether the machine can be a patentee under the patent law, I think that is the question. I think maybe Ashish, if you can just share.
I can only share some experience actually, and I think a lot of this is happening. I can't name a client who they're working for, and I think it's the next Google thing which is happening. It is happening very much in India, and within your nose. When I met somebody in Bombay, extremely big. I mean, I think it's really the kind of AI that is being generated today for identifying a medical situation in times ahead. I think it's gone to a different level. I mean, I'm really not competent to comment on the way it happens and to the extent that it can actually cure things and help us cure things. But it's if I can draw a comparison, I can say that when I sat in a meeting and I learned how this is happening today, I think is the next Google thing actually.
Yeah.
It's comparable there. And
from patent law perspective, what do you see? Maybe?
I think so. What I think personally, in any case, let's break it down into the broad basics. First of all, currently there does exist a natural person hangover in our patent laws, because when you are making an application also, let's assume that you are applying for it as a company, you do have to disclose the names of the individual inventors who are the natural persons, right? So it is only, perhaps that's a technicality, and that's something that can be amended if the policy so feels that there is a possibility of according patent rights onto artificial intelligence, but that's one aspect. The second aspect is you nevertheless have to satisfy the 3 parameters of patentability, which is novelty, utility, and non-obviousness. So if it satisfies all those 3 criteria, I don't see any reason for not granting it, subject to this amendment being brought about where you have to get the natural person's name being listed. The third aspect is that we, at least in India, will then have to get over our hangover of software per se is not being patentable.
embedded.
Because those are the 3 issues specifically,
Yeah.
and the third one definitely specific to India. But if we get over these three aspects, I don't see any problem in granting of patent rights. We had a similar question in a copyright session yesterday, and the entire thing was as to whether you will already have AI which is creating a song, which is creating a film, which is creating various other creative works. What I mean, is there a market out for that? So there were mixed answers, and some people said, look, whether or not there's a market for it, only time will tell, because it's only when that's generated and people receive it that we will see whether it's acceptable or not. Clearly, it would be an alternative. If it is music, it is an alternative to rock, pop, Bollywood music, whatever. It's an alternative. But to shut it out completely from IP protection, I think would be incorrect, because it's innovation, and that's the whole entire purpose of intellectual property.
Interesting. Whom do you attribute it to?
That's going to be So the first time when he said that is human intervention, you bring in the aspects of the inventors.
Correct.
When it keeps on developing, I think we'll have to have a policy change in the way we look at intellectual property laws to say that, look, you can assign a intellectual property to machine X 234. But I mean, I said,
then the question comes whether the AI can assign itself. The second level. So I think that is the food for.
Well, we are very close to that debate actually, no? Whether the God existed out there or not.
So thank you so much. I think unless there is any other input, we can go for questioning if there is any question.
We will have AI asking us questions because they can.
Get rid of the panel speakers and we'll have machines there talking to us.
Yes.
We will be able to anticipate the questions from the moderator and have answers ready.
No, but artificial intelligence, you'll have to keep, as you said, that corporates, then they identify natural persons. But somewhere you will, even artificial intelligence, somewhere there'll be a tendency to find a natural person, because if something goes wrong, who do you penalize? You can't break a machine.
Accountable, exactly.
So somewhere, I mean,
Liability.
because if it has a useful purposes, it has got a abusive powers as well. So somewhere you will have to hold somebody accountable. Like, you can't say "Pata nahi, Allah ki marzi." You can't say that, right? I mean, so I think the idea of finding a natural person will never go out of the system.
I agree to that extent.
I mean, somewhere you'll have to pin the responsibility, because every act has a penal provisions.
Writing. You prove that we are in a lawyer's gathering because you always see for liability and catch hold of somebody.
No, I can't think of any other alternative actually, because
Exactly,
control is embedded in our need to control things actually. Nobody's going to let go of that control actually. Oh, you mean to say that, oh, you didn't do it. I didn't do it. I was walking, I created something which did it. Oh, so the causal link.
That's what I said. Eventually, you can't say God's will. No? I mean,
Be a force measure event actually. I don't know what it will be.
act of God, yeah.
So thank you very much.
Thank you.
Thank you.
Thank you, ladies and gentlemen. Let's put a huge round of applause for this amazing panel discussion here. I would request Mr. Dhir Dhir to kindly do the honors for felicitating my lovely panelists here for putting up such a brilliant show, as we discussed many factors.
One more point, we finish in time.
Yes, definitely. So please do the honors, sir. Ladies and gentlemen, let's put a huge round of applause. Mr. Abhishek Malhotra, thank you so much. Mr. Ashish Prasad, Ms. Deepa Bhandare, Mr. KPS Kohli, thank you so much for being a part of our panel. Indeed, it was a great delight to have you all be a part of this lovely panel. Thank you for enriching us with your knowledge. I would request Ms. Sapna Chaurasia, partner TMT Law Practice, to kindly come forward and felicitate a moderator for moderating this panel very beautifully. Ma'am, may I please have you on stage? Ladies and gentlemen, let's put a huge round of applause for Mr. Hiroj Bharat for moderating this session. Can we have a quick photo op? Thank you so much, ma'am. Yes, can we all kindly come forward and have a quick photo op? Thank you so much, gentlemen. Thank you, ma'am.